Will the court take offense to me keeping my own time?
Well, the time
Yes.
runs
Oh, it's right
for my
there. Never mind.
benefit too.
All right.
But you have lights there, and you have the numbers that go down to the to zero. So
But just keep in mind, it counts up when the time expires. So if you see it go in the opposite direction, you're out of time.
Thank you.
if it's red, you're out of time.
Yes, Your Honor.
Okay.
May it please the court, my name is Alan J. Parker with the law firm Rainey Kaiser Revere and Bell and the Nashville Bar, and I'm here on behalf of the appellant, State Farm Mutual Insurance Company, and I would like to reserve 3 minutes for my rebuttal.
3 minutes, yes, sir.
This appeal is about the appellee's lawsuit being barred by the applicable statute of limitations, which in the state of Tennessee is 1 year for personal injury actions to commence the action against the named defendant. The following dates are important to the analysis of this. First of all, this accident that is the subject of this lawsuit occurred on June 29, 2021. On June 2nd, 2022, the complaint was filed. There's some discrepancy within the rule docket for the trial court on when the summons was issued, but the summons was either issued on June 2nd or June 3rd of 2022. The summons was sent via certified mail to be served on the named defendant and was returned unserved. When it was returned unserved, it was marked return to sender, unable to forward. The summons was resent without being reissued on July 22nd and was returned on August 17th, unserved, marked return to sender, not deliverable as addressed. The defendant in this case has never been served. 461 days after the expiration of the statute of limitations, the plaintiff finally filed the return on service, yet the defendant never got served. When the return was filed, no alias summons was issued. No alias summons was issued until May 3rd of 2024, which was nearly 2 years after the complaint was filed. State Farm then filed a motion to dismiss, which was filed in December of 2023, and not until January 26th of 2024 did the plaintiff file a motion for extension based upon Rule 602 of the Tennessee Rules of Civil Procedure. Because the court considered facts outside of the pleadings in ruling on the motion to dismiss and in ruling on the motion for enlargement of time, it's essential because the court considered those factors, we look at the facts outside of the pleading as if it were a motion for summary judgment, essentially converted the motion to dismiss into a motion for summary
And counsel, this is before us on interlocutory appeal, and I want to make sure that I understand appropriately the scope of our review here.
Yes, Your Honor.
The question we're looking at solely is an issue of excusable neglect, correct? We're not concerning ourselves whether or not Rule 6 actually permits extension of the deadline under Rule 3. We are just worried about assuming that it, for the sake of argument, that it does, whether or not excusable neglect was shown here, correct?
Yes, Your Honor, and the excusable neglect analysis would apply to both the motion for extension and the motion to dismiss. And the crux of everything with this appeal is whether or not there has been any showing by the plaintiff as to reasons that would qualify or.
And for the purposes of the excusable neglect analysis, obviously one of the components we have to consider is any prejudice that your client may have suffered in this case. What difference, if any, does it make that we're dealing with an underinsured defendant here versus an uninsured defendant?
Your Honor, there really is no distinction between an underinsured and an uninsured defendant in this case. In this case, there was a wholly uninsured defendant. I guess based on what's on the record, at least, we don't have any testimony from the defendant themselves with regard to their status of insurance at the time, but there really is no difference with regard to an uninsured versus underinsured.
Okay, for the purposes of prejudice.
Well, let me correct that. For the purposes of prejudice, there really is no difference. There is still prejudice on the uninsured/underinsured carrier, as they have lost their ability to subrogate against the under or uninsured defendant that has not been served. So we're asking the court to look at both motions, the denial of the motion to dismiss and the granting of the motion for extension of time. We're asking the court to all out reverse the trial court's grant of the motion to extend and reverse the trial court's denial of the motion to dismiss. Primary basis is the trial court's abuse of discretion. Now, it's well established under Rule 3 of the Tennessee Rules of Civil Procedure that if process is not served within 90 days of issuance, and the rule is explicit regardless of the reason. If process is not served within 90 days of issuance, regardless of the reason, the plaintiff cannot rely upon the original commencement of the lawsuit to toll the statute of limitations, unless the plaintiff continues the action by obtaining new process within 1 year of the issuance of the original process. So when the original process was issued on June 3rd, or June 2nd or June 3rd of 2022, 1 year from that date is 1 year from that date past the statute of limitations would be when the statute of limitations would have run. It's been well established by this court in Davis versus Grange Insurance Company that an insured plaintiff cannot maintain a cause of action against their underinsured motorist carrier without first properly commencing their cause of action against the named defendant. Moreover, it's been clearly established by this court that when the statute of limitations has run against an uninsured motorist, a direct action cannot be maintained by the plaintiff against their uninsured motorist carrier. Furthermore, when through inattention or negligence or neglect, a plaintiff allows their cause of action against the tortfeasor to lapse, they are precluded from obtaining recovery from their insurer. Simply filing doesn't toll the statute. The statute requires strict compliance, not near compliance. The requirement to serve a defendant is not an empty formality, as this court has held, and yet it appears that the appellee's actions insinuate that they believe that that is the case. It's undisputed that on June 3rd, 2023, 1 year from the issuance of the first summons, the appellee's lawsuit became time-barred. But for the significantly late filed motion for enlargement of time, which was filed after the time had expired, the motion to dismiss would have been granted. So the only issue for this court to determine with regard to both the motion for enlargement of time and motion to dismiss is whether the appellee made an adequate or any showing of excusable neglect to support a granting of the motion for extension and a denial of the motion to dismiss, and the simple answer is no. The trial court abused its discretion in granting the plaintiff's motion for enlargement of time. In abusing its discretion, the trial court identified the proper standard for reviewing abuse of discretion, which was established in Williams versus Baptist Memorial Hospital, reiterating the United States Supreme Court's holding in Pioneer Services. They identified it, but they did not apply it. And that's where the court did abuse their discretion. And also the trial court went against its own logic and reasoning, and went against the logic and reasoning that's been established under Tennessee law in coming to its conclusion that the plaintiff's failure was the result of an abuse of discretion. Now, I won't belabor the 4 issues, but there are 4 factors that the trial court will look at in determining whether whether excusable neglect exists. First is the risk of prejudice to the opposing party.
Counsel, in thinking through those 4 factors, Is the center of this case, in your view, the loss of subrogation, ability to pursue that, and the fact that issuance of a subsequent summons was wholly in the control of the plaintiff in this case? Is that sort of the central axis in this case for you?
I would disagree with that being the central axis in this case. The primary factor is, which this court has held may be the most important factor, is the reasons for the delay and the reasons for the delay and whether that was within the filer's control. Now that is a factor, but the trial court's analysis of that factor is where the most glaring abuse of discretion was, because the trial court determined, despite the appellee's concession at the trial court level in both oral arguments and in their brief, that the third factor does not weigh in favor of a finding of excusable neglect. Despite that, the trial court found that it was within the plaintiff's reasonable control to have a alias summons issued and to get the defendant served and then to file that return. However, the trial court also found that the failure to return the original summons was neither intentional nor deliberate. Now, in the entire pantheon of Tennessee Court of Appeals cases, Supreme Court cases, dealing with these four factors, the fact that a deadline was missed was neither, quote, intentional nor deliberate, has never been established as a criteria for courts to consider when determining the existence of excusable neglect. Additionally, in the appellee's brief and in their responses to the prior motions, they stated that they believed that the defendant was properly before this court. They stated that the defendant, or that they believed that this case would proceed despite the clear and unambiguous requirements of Rule 3 of the Tennessee Rules of Civil Procedure. They never had the defendant served, and beyond that, their efforts were minimal. They sent it the summons via certified mail. They sent the summons via certified mail one other time and did nothing for nearly 18 months, 15 to 18 months. They did nothing until we filed our motion to dismiss. I will address other points in my rebuttal. Thank you, Your Honor.
Thank you.
Good afternoon, Your Honor. My name is John Drake. I'm the attorney for the plaintiff, Mr. Brad Dyer. We submit that the trial court got this correct, that there was no abuse of discretion, and that the court properly found excusable neglect. The trial court's decision here to grant a motion for enlargement of time pursuant to Rule 6.02 and deny the defendant's motion to dismiss was appropriate. Trial court's rulings were grounded on sound legal principle and supported by the facts of this case. The standard review for the trial court's decision to grant enlargement of time under Rule 6.02 is abuse of discretion. This court must determine whether the trial court applied the correct legal standard and reached a reasonable decision based upon a proper assessment of the evidence. The trial court's findings in this matter were consistent with Tennessee law and should be upheld. The trial court properly found excusable neglect. The court applied the four-factor test for excusable neglect established in Pioneer Investment Services, Inc. versus Brunswick Associates.
Counsel, I want to ask you a question about the application of one of those factors. So you state in your brief, unnamed defendant engaged in discovery and was not hindered in presenting its defense. How do you respond to the subrogation argument that is advanced by opposing counsel? And why isn't that prejudice that the trial court really just failed to consider in this case?
Isn't the allowance of the issue of the summons beyond the time through that motion to enlarge time, doesn't that allow for service on the defendant? Where they have to respond?
But I suspect the response will be motion to dismiss, you're outside the statute of limitations. I mean,
Yes, sir.
yeah.
But I would contend that the time had been enlarged pursuant to Rule 6.02.
So are you suggesting they haven't lost their subrogation, their ability to pursue an action against the motorist in this case?
That would be my suggestion, but, you know, I'm not, if I were certain about everything in the law, I wouldn't be
Did the
here.
trial court engage in consideration of this, of subrogation and its impact in terms of prejudice in this case?
Frankly, no. What the court tended to focus on was the Pioneer Investment Services analysis, and they looked at the four factors: the danger of prejudice to the opposing party, the length of the delay, and its potential impact on proceedings, the reason for the delay, and whether or not it was within the party's reasonable control and the party's good or bad faith. And I believe, I may have misstated this in my brief, but I believe 3 of those 4 were in favor of the plaintiff in this case. And it was the first one, the danger of prejudice to the opposing party. The court did find that it would be material prejudice to State Farm if it faced potential liability. But
Let's talk about the reason for the delay. And isn't this something that was entirely within the plaintiff's control? I mean, there's some attempt at service. It's unsuccessful, but issuance of a subsequent summons in this case is the plaintiff controlled that. I mean, there was a mistake made in not issuing it, but isn't this a matter that, I mean, there's no outside party that was preventing issuance of the summons here. And there's not really a factual mistake or confusion, right? It's instead sort of a legal mistake, or am I misunderstanding?
all that was submitted to the court in response to that inquiry was from my paralegal, who indicated that she was under the misbelief that since she was engaging in discovery with State Farm in the active pursuit of the litigation, that there wasn't a need to serve the defendant directly, and I think that was it.
There was no factual indication, though, that there was some kind of confusion as to whether service had actually been...
No, sir.
Okay.
No, sir. The court, in its analysis with regards to the issue about danger to the opposing party, found that there was no proof that in the record that this delay in reissuing the summons prevented State Farm from its opportunity to present any material aspect of its case or caused or would cause unnecessary expenditure of expenses, more discovery, or additional preparation time. But did go on to say that the danger of prejudice to the unnamed defendant is significant in facing potential liability and possible payment of damages, and that therefore they found, the trial court found that was favored the appellant. But all the remaining factors, the length of the delay, its impact on the proceedings, the reason why the filing was late, and whether it was within the filer's control, and the filer's good faith, those all factors all weighed in favor of the appellee or the plaintiff in this case. With respectfully submit that there was no abuse of discretion in this case. Are there any questions?
Thank you.
Thank you.
Briefly, Your Honors, before the four factors could even be analyzed by the court to determine whether excusable neglect existed, there must first be a showing of excusable neglect. Now, the only showing that has been given is that there was a mistake. The plaintiff mistakenly believed that, and this is not quoted verbatim, the plaintiff mistakenly believed that the requirements of Rule 3 would not apply for some reason. The plaintiff, though erroneously, as quoted in their brief, believing, though erroneously, that service was complete and litigation was properly underway. The only party, which this was under their control, the only party that even had knowledge that the defendant had not been served was the plaintiff who'd been holding on to this return of service for over a year. But they then claimed that they erroneously believed that service was complete when everything that they have, every bit of information that they have available to them says service is not complete. So the only thing that can be analyzed is, was it a mistake of law or a mistake of fact? I think this court got to that during my opponent's argument, and it was a mistake of law. The Court of Appeals has repeatedly held that a mistake of law does not constitute excusable neglect. In Jocelyn versus Halford, this court found that, and in Cunningham versus, and I don't want to butcher that, Phrenesis, this court found that a plaintiff's mistake of law in the application of Tennessee Rules of Civil Procedure 2501, in failing to substitute a party within 90 days after a suggestion of death has been filed, was not sufficient
Counsel,
to establish
is
excusable
the
neglect.
insurer now barred from pursuing subrogation? And is that now out in terms of, given the timeline here?
That is my understanding of the law, is that because there is no claim that, or no subrogation that can be maintained against the named defendant, because the named defendant was not properly brought into this lawsuit, the uninsured motorist carrier has now lost their right to subrogate and has been prejudiced. But I will state that prejudice isn't even necessary to the unnamed defendant in this instance, even though they have shown that there is prejudice. Where there has been no showing of excusable neglect, the analysis of whether prejudice applies doesn't even need to take place. This court's held that. So when there is no excusable neglect, because the excusable neglect is based upon a mistake of law, as the trial court had held, the plaintiff mistakenly believed that, based upon the answer, or as the plaintiff has stated, based upon that they believed the defendant was properly before the court. It's still a mistaken belief that that Rule 3 would not be applying. The requirements of Rule 3 would not apply. Therefore, when the excusable neglect is based upon a mistake of law, there is no excusable neglect. There is no prejudice that needs to be shown, even with a showing of prejudice. The unnamed defendant, the appellant, has been prejudiced. Therefore, we request that this court reverse the lower court's ruling and grant the motion to dismiss and deny the motion for enlargement. Thank you.
Thank you very much. Thanks to both of you. That concludes the afternoon docket. Would you recess court until tomorrow morning?
All right.